so we're starting today the Café Pesquisa seminar series. We are proud to receive Professor Hartmut Aden, that comes from the Berlin School of Economics and Law, where he heads the Global Supply Value Chains Competence Center. And Professor Hartmut is going to talk about due diligence in supply and value chains, trade policy, and the Brussels effect in EU Mercosur relations. That means dever de diligência em cadeias de suprimento e de valor globais, a política comercial e o efeito Bruxelas nas relações entre Mercosul e União Europeia. Professor Hartmut has as long as he wants to talk, and then I'll make some few comments, and the audience, if he wants to make some sort of comment in Portuguese, no problem at all, that I can translate to him, okay? Thank you very much. Hartmut,
yeah,
I'm glad to have you here.
Thank you very much, Pedro, and thanks for the invitation. Thanks for having me here at your wonderful campus in Campinas these days. Yeah, so you already announced the topic that I'm going to present on. I'm a lawyer and a political scientist, so I'm not an economist. If you want, okay, this is a bit not as it should look like, but probably the information is all there. Yeah. Probably the fonts are a bit different in this one. I should have taken the PDF. Yeah, so I will...
Do you want me to put the PDF? I have the PDF.
No, it's okay.
Okay.
It's also okay. Probably the others are hopefully a bit less weird. So I will briefly introduce what we are doing in this GSVC Competence Center, but then the core of the presentation today will be about the so-called Brussels effect, what basically means the influence of regulation by the European Union beyond the European Union and all these variations. And also I will talk about the research that we are doing with respect to Brazil. So one of the main purpose of my stay here in Brazil currently is that I'm carrying out interviews in order to investigate how this works with the Brussels effect, and also to look at the variations that I will introduce to you today. Yeah, and then I will not talk too much about the EU-Mercosur agreement because we are just starting to work on that, but I'm very curious to hear from you what you are thinking about it and how it might be related to our research. And I will also briefly talk about recent developments in supply chain due diligence legislation in the European Union, but also in some member states, countries, and then discuss how that might impact this specific variation of the Brussels effect if the European Union goes back to deregulation. That, from my perspective, is a contribution then to somehow reduce the Brussels effect. Yeah, so I'm not an economist, as I said, but a lawyer and a political scientist. So if I'm saying something that you do not understand that at all, just show up. I will be happy to explain everything. So I must not speak all the time. So if you have questions, just show up and then I can explain things more in depth. So this is briefly what we are doing in our GSVC Competence Center. So GSVC means Global Supply and Value Chains. So we are using this term that we specifically not invented but introduced for this Competence Center in order to demonstrate that we are not just looking at supply chains, what of course business administration people would do, and we also have some business administration people who are looking, let's say, at the technicalities of supply chains and also on problems that may occur in supply chains. And probably you are all aware of recent problems with supply chains, and I also heard in my interviews yesterday that also Brazil has had some issues with the recent crisis with the Russia-Ukraine war, and also with several other crises that make it sometimes difficult that supply chains function. So that's the one side. But then we also have people in our competence center who are looking at the value chains, and there the perspective is more about where at the end is the profit remaining. So in the classical post-colonial perspective, so probably in the past we had these value chains where most of the value went to the global north, and Now, what some of the people in our competence center are looking at is what happens then in the global south, what are the variations, and also of upgrading in the global south, and that's we have people looking at the textile sector, but also at the automotive sector here in Brazil and also in other countries. So, and then it's about resilience, but it's also very much on human rights in supply and value chain. So my perspective as a lawyer, of course, is very much related to human rights, but also to the security aspects, because let's say my basis is somehow in security and policing research. So this is the structure of our research center. So in the center, it's basically a little team with Petra Dünhaupt, who also knows Pedro already, and so she's our coordinator and I'm the speaker, and we have also two other people working with us in this central cluster, and this is of course also quite interesting and sometimes also quite challenging to bring people from various disciplines together and to make them discuss and to make them understand each other already. So currently, for example, we are writing a working paper on what means resilience in different academic disciplines, and that's not so easy, because if you talk to criminologists or to business manager or even in law, the term has become more important recently. So and so this kind of coordination we are doing in that cluster, and but we are also facilitating then outreach and cooperation with civil society, also organizing events, conferences, publications, etc. So that's what we are doing in this cluster. I myself am also involved in the C cluster, what is about resilience of legal and illegal supply chains. So this is something that is a bit under-researched. And we have some people, also PhD students, working on these somehow points in the supply chain where something turns from legal to illegal, but then it's of course also more complicated, because it's also about licit and illicit. The whole issue that also plays a role in my interviews here in Brazil of the informal economy, that of course in most countries is not totally illegal. Sometimes it's illegal, sometimes not, but often it's somehow tolerated or is some kind of gray zone. So therefore it's not only, so the illegal supply chains, this is not only about cocaine, but so we have also a colleague who has done empirical research in Colombia on cocaine supply chains and how they managed to get the cocaine to Europe. Quite interesting also. That would be the clear illegal ones, but then we have also illicit supply chains. So that's what we are doing there, and then we are also lawyers and political scientists. And we also have a very interesting work package in Cluster C with my colleague Daniela Hunold, who is a sociologist and a criminologist, and she's doing research on protests in connection with global supply and value chains. So she is also working with anthropologist methods. So they have been doing ethnographic observation during the Belém summit last year here in the north of Brazil. So that's also part of this. And I myself, I'm also particularly interested in questions around accountability. I will also speak a bit about that in my presentation today. Then we have, the cluster B, and that is the one where your institute is very much involved in, because Professor Bruno de Conte, he is part, or he's associated member of this cluster B, where we are looking at the value chains, but also at the growth regimes in connection with global supply chains. That's quite innovative, so that's more in a macroeconomic issue. So that's not me, of course, as I'm not an economist, but we try to connect that and to see how these evolutions of supply chains also can be reflected in the macroeconomic data. So if you're interested in that, I can also connect you to our people working on that. Yeah, and then we have the cluster D. These are the more classical business administration people who are looking. We have a professor in our team who originally is from Russia, and he is one of the most cited business administration persons worldwide, Dmitry Ivanov, on these issues, because he has been working for a long time already on how to find out what makes a supply chain working in a situation of crisis, and how to find that out, how to integrate that also in the system of supply chains. And of course, probably you are all aware of that there was this big fashion, probably 20 or 30 years ago, of just-in-time production. So big companies said, okay, we do not need any stock anymore, and everything arrives just the moment where it goes into the production. And with the first crisis of supply chains, of course, companies working with that, they have been in a total mess. So now it's very much about, and what they do is very much about knowing how to find out, how to prepare for these situations. So this is a big topic now, and probably they also contribute quite nicely to this academic debate on that. But of course, it's also practically very relevant. And then finally, but also very important and also very interesting, very much connected to the other clusters, our team in cluster E, they are looking at the sustainability issues. So how to measure and also how to somehow evaluate the relevance of sustainability in what companies do in supply chains. Currently, they have been working a lot on the medical technology sector, what's also quite interesting. And we, of course, by the way, we also learn a lot of that sector, and are quite astonished how much the medical technology sector is nowadays in Europe depending upon China. That's quite interesting to see. So yeah, you see we have many different aspects, and we try to bundle that together in order to create interdisciplinary synergies in our cluster A. So that's our team. So it's a big team of principal investigators with 13 professors. Then we have 12 researchers associated that
Hans-Jörg Herr. Hans-Jörg Herr, there?
Yeah.
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 And Petra Green.
Yeah.
Okay.
Yeah, that's indeed. Yeah, yeah. These are probably the people whom you know.
Yeah.
Yeah, yeah. Yeah.
The economists.
Yeah, yeah, so Hans-Jörg Herr is one of our, he probably has been here also several times in campaigns.
For more than 30 years.
Yeah. And he's now retired, but he's still very much into these topics. So he's one of our associated members, and we are very happy to have him because he's always great in commenting everything. So he's really very knowledgeable, and also is very, and you need people who are able to connect the different aspects and who are also open for these kinds of interdisciplinary reasoning, and he's really great in that. So I like him very much for that, and we are very happy to have him, and that he did not say, okay, now I'm retired, I'm always going on holidays, but that he is indeed very much involved in what we are doing there. He's really very present in the competence center. Yeah, then we have also 2 more doctoral students from next month, even 3, who are financed by the university for a PhD that is connected to the competence center. And probably for you, most interesting, we have 7 cooperation partners in 3 countries, and here Campinas is one of our partners. The associated members are mostly people from our university, but now we are trying to open it up also a bit for people from other universities. And we have basically 6 academic disciplines involved. I probably already mentioned that, so political science, economics, business administration, law, sociology, and criminology.
You are recruiting our students, right?
Yeah.
I see it. Yeah, I see it.
I was wondering which topics you mentioned about the relation of the illicit and illicit supply value chains. In Brazil, you mentioned you don't work only with the drug traffic, but also others. Which ones would that be, the topics that you research?
So when we look at licit and illicit, so as I mentioned, it's very much about the informal economy. But then it's also, so for example, I have a PhD student who is looking at waste supply chain. So that's not a classical one, but that is often going from the global north to the global south, or even inside the global north. So for example, from Germany to Albania, what is one of the candidate countries for becoming a member of the European Union. So these kinds of, and there, probably the hypothesis is that everywhere where you can make a lot of money with not complying to the rules, there will be some people, organized crime style people, who use that. And then, of course, it becomes clearly illegal. And then in between, there are also these gray zones that are often related to the informal economy, what means individuals who are, and that I learned also here in Brazil in the textiles sector, people working from at home, that is often then not really, or I had a very interesting discussion yesterday with someone here from the faculty on family agriculture. So that would be also where we would say, okay, this is not illegal what they are doing, but it's also not completely regulated. So it's not, they are not formally employed, they are not paying social insurance contributions. And that's quite interesting to see, and we are still also looking for economists who are working on that more intensively, because this is also quite different from country to country. So there are studies saying that in India, for example, that is also one of our target countries, the informal economy is much bigger than the formal economy. And then, of course, all these initiatives from, for example, big transnational companies to know more about their supply chains will end probably where the informal sector starts. There they usually do not know anything, because then of course it would also become quite shady, and probably also not very good for their reputation to know much about that. Yeah, so yeah, these are our international focused countries. So Brazil, Colombia, and of course Germany is in Europe. We're also looking at Spain a bit more closely, India, Turkey, and South Africa. Sometimes also building up on former research relations. So we have already had previous projects also with Brazil, and specifically also with Campinas, and indeed also with people like Hans-Jörg Herr. So there we are looking at this, and then yeah, I already talked about the synergy. So this is basically the empirical part, and we explicitly did not select 50 countries because we are not doing a lot of quantitative macro level studies. Of course our economists do that, but most people in our team are working with qualitative methods from ethnographic observation, interviews, etc. And also, yeah, the lawyers on the team, they also more work with qualitative methods. So therefore we have currently a limited number of countries that we are looking at, also in the perspective to compare them. So we find it really very interesting to compare, for example, what is going on in India and in Brazil, but also in South Africa. So we are now more or less in the half of this first period of the competence center, so maybe that we add a few more in the future, but currently we are working with these countries. Yeah, okay, that's basically again the structure. We don't need that. And then let's talk a bit about the Brussels effect. And I will talk about a bit about the theoretical foundations. What is quite interesting, you may have heard that, and probably this does not happen very often, that someone with a single publication somehow establishes a whole academic debate. And this is colleague, her name is Zanju Bradford. She's a professor at Columbia University in New York City, but originally she is from Finland. So therefore she's probably quite well placed. So she is European, but now a professor in New York. So probably she's quite well placed to look at Europe from outside. And that's also quite interesting for people as me who are working a lot on the European Union, that some of the best and interesting studies on what is going on in the European Union and in Europe are coming from outside Europe, because probably people are able to look more from a distance at what is going on in Europe. So this is a nice example. And basically it started with a paper that she published in 2012 in a law school journal. And of course a law school journal, this is not something that usually will be very much cited by many people. But for some reasons many people became interested in that, and then she also got the opportunity to extend that to a book that has been published by Oxford University Press in 2020. And at latest since then, probably already a bit before 2020, but at latest since this book has been published, this is something that is really very broadly discussed. I will also give you some examples, and I also think that's also very interesting and also very relevant debate. And it's basically about the impact, as I said earlier, about the impact on what the European Union does in terms of regulation outside. One of the most studied case is the General Data Protection Regulation. There have been many studies showing that this has been quite influent everywhere, and I will also show you from a legal perspective why this has been influent. But it's not only that, but it's basically on all kinds of product regulation already, and I will also talk about the variations of the Brussels effect. So this is my first example, and the one that also in that 2020 book by Emily Bradford. There's also another book that she published in 2023 on the digital issues that is also building up on that. As a lawyer, I always say, and also as a political scientist, it's always relevant to look at the text of the law in order to understand what the Brussels effect is here. And if we look at the text of the law, it's basically this clause in Article 3 of the General Data Protection Regulation saying that this regulation is not only applicable inside the European Union, because a regulation is a law that is directly binding, and this is also one of the strengths of the European Union. I will come back to the fact that the European Union is not a state, but the European Union can make laws that are directly binding not only for the member states, but upon everybody. So that's the big difference between the European Union and an international organization. So if the European Union issues a regulation, it will be, and in the moment it enters into force, it will be binding for everybody within the European Union. But then we have these pieces of legislation that somehow open it up to make it also binding for people and basically for companies outside the European Union. And here you see how it works. So if someone, so the controller, that would be, for example, a company processing personal data outside the European Union, wants to process data on people who are inside the European Union, then they have to comply with the rules of the GDPR if they are offering good services, and it's even if it is not for money, so even if it's for free, that someone offers, of course it's about online services. The second one, the monitoring of behavior, that's probably not as relevant, but the first one, that is really highly relevant for companies, because this means that as soon as a company anywhere in the world, in Brazil, in India, the United States, of course it's very relevant for the United States because all these big tech companies are there, if they want to provide services to people inside the European Union, so if I have a credit card from Masters or American Express, or if I use an Uber or whatever, of course they all use my data. And if they want to have customers within the European Union, they have to comply with the General Data Protection Regulation. So that's the easy but also very effective mechanism behind that. That's a legal mechanism. What we are also talking about today is what is the effect beyond that. So, of course, that's a hard legal side. You want to possess data of European Union citizens, then you have to comply to all these rules. If that's interesting to you, I can also talk later about what that means concretely for the GDPR. But then this also has some interesting side effects. So, for example, probably the most interesting side effect that also plays a role in this book this 2020 book by Anya Bradford is that companies sometimes also apply these rules then to people in other parts of the world. Why? Because for the big tech companies, specifically for the American ones, Google, Meta, etc., it's often for more efficient for them and also comes at lower cost if they apply the same rules worldwide. And this is an important part of the Brussels effect, that then companies will apply this also for customers outside Europe. What means that somehow with this variation of the Brussels effect, indirectly the European Union is also increasing the level of human rights protection outside in many other countries of the world. So that's really quite interesting as an effect. But we also know now that they will only do that if it does not come at a high cost. So in the GDPR, a nice example, we also have the right to be forgotten. You may have heard of that. That is a new right that has been first been established by the European Court of Justice in a court ruling back in 2014. And then it was also introduced as an article, Article 17 of the GDPR. That means if you are somehow mentioned online and you don't like it. So if you think about how things work today, 50 years ago, if people were discussing in a pub about something, about a rumor or so, that was very easily forgotten. So two weeks later, nobody really bothered about that. Now everything is online. And as long as nobody deletes it on all the servers, it will never be forgotten. And there was an interesting case of someone who had a very small criminal conviction 20 or 30 years ago. And when you Googled this person, it still popped up the first.
Gosh.
Yeah. So, and he won the case before the Court of Justice because they say, okay, in these extreme cases, the freedom of the press or the freedom of opinion has to be weighed lower than this individual interest that after a time, if it is, of course, if you're a serious killer or so, then you don't have the right to be forgotten. But in these minor cases, then it makes sense that this has to be erased from the internet. Therefore, this is also called the right to evasion. Yeah, and why is this not covered by this de facto Brussels effect? Because Google and the other companies concerned, they have to look at each individual case because it has to be weighed. And you cannot, at least still, you cannot really do that. Potentially they have some kind of AI to help them with that now, but they still have to employ quite a lot of staff to do that. And so it really comes at a cost. And therefore, that's the capitalist logic. This is only applicable for people in the European Union. So if you try probably in Brazil, you will not manage to get your things erased. If there's not a Brazilian law, potentially. If now, of course, many countries also then have copied this into their laws. That would be then another variation of the Brussels effect, and then it would be also applicable, of course, in these countries. Yeah. So that's my first example. The next one is a so-called REACH regulation, but this is just one example of many issue areas, so we could also apply that to genetically modified organisms, or it could also be with pharmaceuticals. And basically, the rules say if you want to go to the European market with your product, so therefore it's also very much its own. And the Brussels effect are the importers. So if you want to import any kind of chemical substance to the European Union, then you have to comply with this regulation. that is now already 20 years old. It was extremely contested also inside Europe when it was introduced, because it really comes at a cost for companies, because this means that now all chemicals used, even old ones that companies always used, they have to be tested in order to make sure that they are not dangerous for human health, for the environment, etc. So, but the advantage then for a company is that this is really the single gatekeeper. So as soon as you comply with this regulation, you have the door open for the whole European Union market, not only for one of the member states. And that's also quite interesting, because this is also some kind of distribution of labor. So you can go to one member state administration and say, I want to sell this substance on the European Union market. And then they will say, okay, it has already been tested, or it has not yet been tested. If it has not yet been tested, then it has go through these procedures. Very similar also for pharmaceuticals. And then as soon as the answer is yes, it is okay, you can put it on the market, then you can sell it everywhere in the big European Union market. Mm-hmm.
Yeah, so does it need to be tested by, well, institutions in the European Union, or do they accept also like foreigners to test their own products?
Yeah, this is indeed coordinated by European Union administrations. There is also a European Union agency based in Helsinki doing the coordination for that. And then you go to one of the member states administration. They will somehow coordinate that together with the European Union agency. They will probably also, so for example, if you have scientific data that has been generated already, for example, for other markets, then they will accept that for the process, and then they will check if this is reliable. So you don't have to start from zero if it has already been done elsewhere. But then at the end, the European institutions will then coordinate among itself, and then every member state can say, oh, we think we should be more cautious with that. And then at the end, the decision will be taken. Of course, in the concrete case, this can be extremely contested. You may have heard of this pesticide called glyphosate. In the US, it's been produced by a US company called Monsanto. There it was called, or it's still called, Roundup. And in principle, it's used for gardening. And then the German big company Bayer, they made the mistake to buy Monsanto. And then they bought with that all these liability cases for glyphosate. So it's really, they have to pay now really very high compensations in the US for that. And that's also interesting because, and therefore I also left the last sentence here in this definition, because its provisions are underpinned by the precautionary principle. This is also extremely important in these contexts, because the precautionary principle is one of the main issues of contestation between Europe and the United States. Because the precautionary principle does not exist in the United States. It's more or less the opposite of the precautionary principle. So the precautionary principle means if there is a risk. So for example, this glyphosate, we know that there have been cancer cases all the time. Of course, the producers say if you apply it correctly, then you don't get the cancer. But then, of course, they have also had these cases, so therefore it's still very contested. It's still not prohibited, even in the European Union. But the precautionary principle says that if there is a risk, then public authorities can already intervene if the risk can lead to a severe damage, for example, the death cases. Then state intervention can come at an early stage and say, yeah, we opt for the precautionary version, and therefore there are very strict limitations, or it could even be prohibited in these cases. Not so in the United States, also applicable for pharmaceuticals. It's more or less the opposite in the United States. So if you want to put a substance or a pharmaceutical on the US market, then you just do it. And if something goes wrong, so if people get health problems, die, etc., then the companies have to pay punitive damages. There are big law firms specialized on that. I frankly prefer the European version because punitive damages is somehow cynical. So you wait for people dying and then the family gets a lot of money. It's a bit cynical, so I'm a fan of the precautionary principle because of that. But this is a big problem also for global trade, and this is one of the reasons why the European Union and the US never managed, even under Obama, never managed to conclude a free trade agreement because the US definitely they do not want to move to the precautionary principle. Yeah, because they have all this tradition, but even if it's a tradition, probably it would be wiser to to change that in the future. So that's also an interesting example. And then coming to a more recent example that is also a bit closer to Brazil, that is a deforestation regulation that has been passed in 2023. So again, a regulation that is directly applicable everywhere. And if you look at the wording, you can already in the wording say, okay, this is very much about a Brussels effect, and it's also very much about Brazil. So it's really very relevant if you look at, okay, products that contain and have been fed with or have been made using relevant commodities, namely cattle, cocoa, coffee, palm, rubber, soya, and wood, with a view to minimizing the European Union's contribution to deforestation and forest degradation worldwide. So this is really very explicitly the Brussels effect. It's still at the beginning, so we don't know if this will work and how this will work and what kind of contestation, but this will definitely play a major role also for all the sectors concerned by that also in Brazil and also with the Mercosur European Union trade agreement. Okay, if we look at the theoretical framing, so that's more the theoretical framing used for the Brussels effect, also by Anu Bradford. And one of the main theoretical frameworks used for that is the European Union's regulatory power, or also regulatory soft power. Why soft power? Because the European Union is not a state. And in a way, Europe very much suffers from that, specifically now, because in everything that is related to external policy and to military is still under unanimity in the European Union. So this has really caused enormous problems in recent years, also with the support for Ukraine, because unfortunately there was this government that now has disappeared since a couple of months in Hungary. And if you need unanimity among the 27 member states, you only need one that is a bit crazy in these issues, and then nothing goes. In all other issue areas, chemicals, deforestation, and it's under majority voting, so if there is one or two crazy governments, no problem. But then if you need unanimity as for foreign policy or for military issues, this really blocks everything. And so this is one of the reasons why the power of the European Union is still limited, even if over the time there are many interesting studies showing that the European Union over time has become more similar to a state. Yeah, it could be better. I would say things are evolving, and also somehow now the recent situation with Russia and Ukraine has been a game changer. So everybody sees now that it only works with more cooperation. But then when it comes to decision making, it's still difficult because you need unanimity, what often means that decisions will be taken by not all. So, but there's a lot of cooperation going on, and that's also not so recent because when it comes to aircraft, for example, there's this long cooperation with Airbus, and they also have a military branch. So, and of course, all these military issues have become much more important. Again, they were not relevant at all in Europe for many, many years, but now, unfortunately, they have become much more relevant in recent years because of the Ukraine war. Yeah, so this is evolving, and what is also somehow complicating, but potentially also somehow creating interesting developments is Brexit, because the UK was one of the players. They were specifically when it comes to technology and also for military technology, they were always very keen to cooperate with the other European Union countries. There is a lot of joint ventures, cooperation, joint companies, for example, between Germany, France, and the UK. And this, interestingly, mostly survived Brexit. So it's still there. And yeah, so even more under the, we don't know yet now, under the very new British Prime Minister, but under the previous one, Starmer, he was very open. So there was already somehow, everybody had the feeling Brexit is somehow fading away because they're coming back somehow. But yeah, in other issue areas, probably this will not be for very near future, but for all these technological issues and also for research, there's a lot of common European research funding, because indeed this big space is of course a big opportunity for cooperation. So the European Union is a big research funder also. Yeah. So the basic idea of this soft power theory is that somehow regulation compensates for the missing hard power. And this is probably somehow true, that because the European Union has always needed that to coordinate inside the European Union, and then more and more we have these examples, and I already only showed you 3 examples, but I could show you dozens more examples where this works for any kind of products. And it not only started in recent years, so this is not only since Bradford invented these terms, but somehow this already exists since the early days, for example, of the regulation of car emissions in the whole environmental sector is very much concerned by that back to the 1970s already. So that's the regulatory soft power. And then for what is also for supply chain due diligence quite important are accountability theories that I use a lot. And there I mostly work with theories that have been developed back in the 2000s by a research group at the University of Utrecht in the Netherlands by Mark Bovens and others, because you can nicely apply that to different issue areas. So I've been working on accountability in different issue areas, also very much on police accountability, for example, and you can nicely compare different issue areas, but also compare accountability settings across countries. And we are looking or using that also for comparison of accountability mechanisms in supply chains, and I will talk a bit about the reporting duties in this context. So what is the theoretical framing? Basically, it's this very relatively abstract term of an accountability forum. And an accountability forum always has 2 actors in it. The one is the actor who has to be held accountable, and the other is the forum to which this actor is somehow responsible, so has to respond. So in a supply chain, that would, for example, be the global company that is somehow organizing trade along a global supply chain. And then it would be, for example, a human rights institution or a specific body created somewhere in the world to monitor what is happening along supply chains. So you can very nicely apply that to any kind of accountability setting. So this is why I like to use that for comparative research. And it's always a relational concept between these 2 kinds of actors. And then accountability is also quite a convenient term in English. Unfortunately, we did on the comparison of police accountability in 5 countries, potentially in Portuguese. I don't know.
Responsabilização.
Yeah. It would be, of course, we also have the term responsabilité, also in French, for example. That's very close to that, but not exactly accountability. I had the funny thing that I wrote an article in English, and usually I also write myself in French, but then I did not have time, and then the publisher offered to translate my text from English to French, and then the definition of of accountability was responsabilité et responsabilité. It was a tautology. So because they don't have a term for that, and it's and also in German we don't have a term for that, so I always use the English term now. Yeah, yeah. But it's an umbrella term for all these different sub-concepts, and this is when I talk about accountability, this is how we are using this. Yeah, so, and then for the process effect, also there are different variations of that, but there's also this interesting distinction between de jure and de facto process effect. So de jure would more be the direct legal effect, so with a law being created, but also with these examples that I showed you, that would be the de jure one. And then the de facto one would be any other kind of effect. So, for example, the Google case that I mentioned earlier, that they just apply the same rules everywhere to all people in the world. If it is not costly for them, that would be one of these variations of de facto process effect, but there are more. Yeah, so some examples. So that the first one is the Google one that we already talked about. It's also very much about copy-pasting. In a federation, so Germany is also a federation, and even in a federation you have that. So if you're lawmaking, and there's no copyright on laws. So if you're a parliament or a government and you want to make a new law, of course, the first thing what you do is what is already there in other jurisdictions. So therefore, there's a lot of copy-pasting going on. And this is also one of these elements of the de facto process effect, that somehow elements of the GDPR pop up in laws in other jurisdictions. So, for example, the United States, this is really not a country that has a long tradition with data protection. But if you look at the California Consumer Protection Act, you find some elements in that law that are more or less copy-pasted from the GDPR. And yeah, from the European Union, this is of course a positive thing because that facilitates trade, and if you have the same kinds of rules. So therefore, this is indeed one of these elements of the process effect. And then the third variation is also quite interesting, and I also observed that in my interviews here in Brazil, that this is going on very strongly in Brazil. These are civil society groups that are looking at what is happening in countries in Europe or in the European Union. This is already my second time that I do interviews on these kind of issues in Brazil. We already started last year with a series, and also now. I'm really very astonished how well civil society people know all these instruments. Probably better than some civil society people in Europe. That's really amazing, and they use that also very strategically. Of course, nobody is really bound to that, but they can, for example, use that for lobbying and saying, okay, this is working well in Europe, we also need that. And you have this supply chain law here in Brazil that is pending in the parliament, probably will not be passed before the elections. And the same also for AI regulation. So civil society groups can say, okay, you see it works in Europe, why not also having that in Brazil? So that can be used very strategically, but it can also be used strategically in order to use the European instruments themselves. So for example, the complaints and redress mechanisms. Of course, if there are interesting cases with people from the global south. So for example, a farmer from Peru, he brought a legal case to a court in Germany saying, okay, I have my farm here in Peru, and due to climate change, unfortunately, I will not be able to live here anymore in the near future. And you German companies, you are co-responsible for climate change, so therefore you have to pay me a compensation. Unfortunately, he did not win, but this was a very good case. And now also for supply chain due diligence, there are also complaint mechanisms where people who say, okay, we are underpaid or the working conditions are unhealthy, they can also make a complaint to the relevant administrations, or sometimes also going to court. And of course, this farmer from Peru, he would never have been able to do that himself. How should he know that this exists? but you need civil society organizations who are facilitating that, and that's what is happening in quite a few countries. And then, of course, you need other civil society organizations in Europe, and there are some, for example, Oxfam. They have branches in many countries, and then they facilitate that. And there are quite also some human rights civil society organizations. So that's really very interesting how this is used, and this is indeed, at least from my perspective, also one variation of the Brussels effect that I learned a lot about also here in Brazil already, and that I will probably also use for my research publications. Yeah, there are of course also some limitations. These are all only some examples of limitations. So the example that I showed you, the extracts from the 3 regulations, they are all very clear in their wording. And this extremely facilitates the Brussels effect. If you have fuzzy, compromise-style European Union legislation, it's already a problem to somehow implement that inside Europe. This will probably not be likely to develop a Brussels effect. Yeah. Then the other issue, and there's an interesting study that people have done a couple of years ago on soybeans going to the European Union market. If you do not depend on the market and can say, okay, if the Europeans, they have all these deforestation rules, I don't like them, and or they have due diligence rules for working conditions, etc., we also don't like them, then we just sell our soybeans to China, forget about the European clients. Then, of course, then the Brussels effect also cannot work. Yeah, and then also quite interesting, and this is also something that I observed here in Brazil, or was also part of my interviews here in Brazil this week and last week, legal provisions in third countries somehow contradicting EU law, and that may be an issue also for deforestation. So if the Brazilian forest law defines deforestation differently than the European Union regulation, what will be applicable at the end? So these are probably questions that are still only at the very beginning, or even a bit crazier, the Chinese case, because this summer they passed a law saying that Chinese companies are not allowed to comply with supply chain due diligence laws. That's crazy, huh? I don't know how they want to hold that through over time, but it's really showing, okay, they don't like that. And there's also this debate now on the Beijing effect. They of course understood this mechanism and tried to somehow copy paste that for specifically also for African countries, but potentially also for the Mercosur to some degree. So therefore they don't like these ambitious European Union regulations. And then of course they also have all these issues with human rights. That makes it also, of course, still much more difficult compared, for example, to Brazil, where at least, let's say, in the books, the human rights are there, even if they are not always respected properly, but they are there. Why? But if you go to China, of course, they also have laws for many issues, but the way in which the legal system works is totally different.
Hartmut, perhaps you could explain to them what is post-omnibus CSDDD.
Yeah. I will also come back to that.
You come back later.
Yeah, I come back to that.
Okay.
So these are recent changes. I will briefly talk about that, because indeed there's also a trend in Europe that I will briefly introduce to you in a minute, saying, the European economy is not sufficiently competitive worldwide, and is also a report that has been written for the European Commission. The Commission is the government of the European Union, and they asked for a report written by the former president of the European Central Bank, Mario Draghi, and building upon that, they developed a whole package of legislation in order to somehow reduce administrative burdens for companies. And this is what they call the Omnibus, because it's always about many different pieces of legislation where they put these deregulatory approaches. And then indeed, it's an interesting question. Still probably too early to really prove that empirically, but we think indeed that this will somehow reduce the Brussels effect. Because if you have less rules, then they will also be less influent outside Europe. It basically applies on imports, but also on exports. So what means if something has been produced based on deforestation, and of course we also have deforestation inside Europe. What is also an issue with that? So it's not only about deforestation world, but it is about deforestation worldwide, but it is also very much about deforestation in Europe, because that's equally also relevant for climate change, for example. Yeah, but this is new, so it more or less is still entering into force, so we still do not know much about how it will work, but it's a directly binding regulation. So in EU law we also have directive that in the first place the member states have to transpose into their laws, but the regulations are directly binding. This is a big difference between the CSDDD, the Corporate Sustainability Due Diligence Directive, because this is only applicable after the member states transpose it, while the Deforestation Regulation and also the GDPR and also the recent AI Act, they are all regulations. That means as soon as they enter into force, and more or less they all somehow entered into force already, sometimes with some delays, but they enter into force and they will be binding upon all companies directly. And so therefore we will probably know quite soon how this works with deforestation. And interestingly, the deforestation regulation has been more contested for the impact on people planting trees inside the European Union than on these global issues. So most of the lobby work against this regulation was from landowners who grow trees on their plantations, and that's quite a relevant business also in Europe. So you're probably not so aware of that, but it's quite a big business, and even more in the Nordic countries, so in Sweden or Norway, for example. But not only there. It could relate, yeah, because of course an interesting question is for deforestation how to prove that. This is also something that I have been discussing with some people here also at the university yesterday. So how can an exporter prove that this is not coming from deforestation? Because, and these are also these intersections between Brazilian law and European Union law. If, for example, Brazilian law says that a certain percentage of a farm has to be planted with trees, then of course this needs to be proven somehow. I found it quite interesting. I met people yesterday who are working on that they think, okay, with modern technologies this is quite well feasible because everything is now covered by satellites, etc. So therefore it's probably, and then it's likely to work with certification. So if you do everything in a regular way, and then everything is, you have the data is there, and then you get a certificate that your products are okay and not related to deforestation. Again, of course, it's a question: what happened then to the illegal ones? Will they then? Probably they will either then open some kind of shady supply chain somewhere. Potentially it will also remain inside the country. So very interesting questions also for further research. What then might happen to these, because we know that there is a lot of illegal deforestation also in, yeah. And then the other issue, we also have master students also from Brazil who also worked on that. The other issues, of course, what happens in times of policy change. So I supervised a master thesis by a Brazilian student looking at how these deforestation rules with respect also to soybean production were implemented under the Bolsonaro government. It was basically the laws were not really changed very much, but they were just not implemented. That's also, of course, an issue that a government can also somehow hamper these instruments by just not implementing them. That can, of course, happen everywhere in the world where you have these governments who don't like it. There's a big discussion also with the US government because, you probably are aware, they think there is no climate change. They think nothing has to be done. And this also make pressure on Europe to not to apply these rules. Of course, this can be a problem then for the implementation if you have important countries such as the US. And for the US, unfortunately, it's now across all policy area. It's also for all these data issues. So the European Union now has very good rules on, for example, content monitoring online, the Digital Services Act. So if you are a big provider, you have a responsibility if there's child porn, etc. you have a big responsibility to take it down. Of course, it's again costly for the companies, so therefore the Trump administration is lobbying very much to soften that and not to implement that. And more specifically, not to issue fines, and because that's the interesting instrument that the European Commission has. It can issue fines against these companies, and they are quite high because it's a percentage of the global net turnover. And if you look at the global net turnover of Meta, for example, Google, we are talking about quite high numbers. It's even interesting, I've also been working a lot on the European Union budget because I was also a budget auditor in a former life. So therefore I'm also very much interested in budget issues. You can even see that now if you look at the European Union budget that they make quite a lot of money with these fines that mostly US companies have to pay for these competition breaches or for these DSA breaches. Yeah, so many interesting aspects of that. Perhaps in order to go back a bit more to supply chain due diligence as one. Again, this is connected to the Brussels effect because this is what Marie-Therese Gustafsson and others have called the foreign corporate accountability. So this links somehow the accountability issues with the Brussels effect issues, because that's another variation of the Brussels effect. If you have a jurisdiction, as for example the European Union or France or Germany, saying we establish a supply chain law, and of course the supply chains are not ending at the German border or at the European Union border, but they are also involving the suppliers from other countries. Then the interesting question is how deep does this go into the, so often it's only the so-called tier one, so the direct providers, but if you would look at the whole supply chain, then of course it could then cover a number of countries, and so therefore they call it, and also we use this term now for our project, foreign corporate accountability, because this is not the traditional corporate accountability, but it is also involving companies outside the country, usually countries somewhere along or at the other end of the supply chain. Yeah, so that's the linkage between these issues. Oops, why does that not work anymore? Ah, now it works. So yeah, basically this is very much about then if you look at the Corporate Sustainability Due Diligence Directive, it's called Sustainability Due Diligence Directive, but it's also very much about human rights along the supply chain. So it's basically about the answerability and the corporate conduct, but it's also about non-legal means in that. And that's basically where we use this term of foreign corporate accountability when it comes to due diligence problems, human rights problems, somewhere caused along the supply chains. And this is of course quite, I would not say revolutionary, but this is something that companies in the global north simply did not do for many, many years. So they just look at, okay, we want to buy as cheap as possible. And what happens in the production countries, it's not our business. And you still have, if you discuss these topics with business people in Europe, you still have many people at management level who are exactly thinking like that. And also in governments, you have these people who are always argue, okay, the Chinese do not bother about that, why should we? If we do it, we only have problems on the market, so therefore we should forget about that. That's probably, and you find that even our government party, for example, in Germany, they think that. So therefore, this is quite revolutionary, and it's even so revolutionary that at the end, many companies do not know much about their supply chains. They know, of course, where they buy the products and to whom to pay the bills, but then they don't know much about where this is coming from, how this has been produced. And there have been some game changers in that. And one of them, and that makes it also interesting for international comparison, are the UN Guiding Principles on Business and Human Rights that were passed in 2011. This is, of course, soft law, so it's not binding. But it has been a game changer because now you have, in many countries of the world, you have social movements, trade unions, etc., saying, okay, this has to be made more binding. So this is also somehow the background of the debate in Brazil on having a binding supply chain due diligence law. And somehow European countries, for some reasons, became forerunners because France started already in 2017 and then also Germany in 2021. So therefore, yeah, this is an interesting trend that we now have, this trend to somehow make these general soft law rules that have been established with the UNGP in 2011 to make them more binding. But of course, it's still very much contested because people argue, okay, this is too costly, this is too bureaucratic. And what we have been looking at in recent months are the debates on reporting obligations, because from an accountability perspective, what you need, and I will come back to that a bit more in depth in a minute, what you need is information. And usually these instruments, many European Union pieces of legislation, and probably you also have that in Brazilian law, say, okay, companies have to report on this and on that, and you need the data and they have to regularly update this. And then companies said, say specifically for small and medium-sized enterprises, this is a lot. We can, or farmers complain all the time and say, okay, we cannot do all that, give all this information. So this is really very much contested. And yeah, so that's of course an issue, and that's also a big issue in these omnibus debates.
Is it binding?
Yeah.
I didn't understand. Is it binding or not?
The UNDP not.
No, for France and Germany,
Yeah.
like the corporate responsibility of recording all the...
Yeah, it's binding, but sadly, at least for the German, so the French and the German approaches, they are quite different. At least in the German one that we studied a bit more in detail, it is binding, but it's not implemented because the government does not like it, and therefore it's simply not implemented. Yeah, so you have that everywhere in the world, unfortunately. Yeah. Mm-hmm. Yeah.
I don't know if you with human rights as well.
I think it was with the forced labor regulation.
Forced labor,
Yeah.
yes.
They also blamed,
Semi-slavery.
they also blamed Europe for that.
Yeah.
The background is that there has been this judgment that Trump can only introduce tariffs for 100 days without asking the parliament.
Yeah.
And therefore, he needed a new reason every 100 days. And therefore, he somehow found that one. That's really totally ridiculous. But there are also interesting studies showing that specifically the debate on forced labor has also been somehow misused by some business associations, specifically in the US. So that's really quite strange how they use that. And of course, if you see how Trump systematically ignores any kind of human rights elsewhere, this is probably only because of the tariffs.
But that makes me think about how accountability can be used for political reasons, even though the reason itself doesn't exist.
Yeah, probably in these kinds of systems you can misuse everything for everything. So, indeed. So probably, and people who are somehow opportunists, they probably so probably the Trump administration, they would even use climate change arguments when it's good to say, okay, the Europeans or the Brazilians have to pay tariffs. So therefore, even if otherwise they ignore it. So therefore, yes, this can be definitely misused. But this is also related to a broader question that is behind this. Are we still living in a rules-based international order, or are we moving away from that? Because in a rule-based international order, of course, it would not be possible to come with this kind of ridiculous arguments. Yeah. So and that's a problem also behind implementing all that. Since 2011, and then already under the first Trump administration, and then with the Russia-Ukraine war, the global system is moving away from a rules-based order. Indeed, and I would even say that the good thing in the US is that the US is also a federation. So I went to a conference in California earlier this year, and you really see the difference. So in California, you have a government, and you have also many people who say, no, we don't do that. We find we find ways to somehow avoid this. So therefore, indeed, this makes federations are much stronger. This all I really think that this is an important point, that in a federal system, a change in government cannot immediately change everything. So there is a risk, for example, in France, that there might be a Le Pen government. That could be probably more dangerous for the European Union than many other issues, because it's an extremely centralized system. The president is very powerful. So if they have the president and then start blocking everything in the European Union as a big European Union member state, that could be really a problem. You don't know. We also have this Italian government that is also somehow based on this old nationalist, right extremist Mussolini party, and she is astonishingly pro-European. So it's, of course, with the exception of migration. Migration is a crazy thing. So Europe has never been so tough on migration as currently. So that's. But in all the other issue areas, even for supporting Ukraine, for example, Italy is still very much on board. So that's quite interesting to see. And indeed, I agree that the federation is more stable as a rules-based order. So also for the German system, and I guess even for the Brazilian system, as a central government, you could not immediately reverse everything. But it would take a long time, and you would need majorities also in the bigger states, and then also federations. Also, there's a lot of political science research showing that if you have this majority at the federal level, then in the single states it will be often going to the. So this is this kind of also voters-based checks and balances system that works much better in federations. This is also why I find that indeed also Brazil is an. Oh, thank you very much. Brazil is an interesting question for comparison, because it's also a federation. Also India in a way is also a federation. And then to see, okay, what really makes a difference to the centralized systems, where with a change of government you can immediately change everything. Yeah, so perhaps back to this. We wrote a conference paper on that. It's online on ResearchGate if you want to read it, on these contestations about reporting obligations, and I will only briefly summarize that. We have already been talking for too long probably. So there are these competing narratives. On the one hand, civil society saying, of course we need reporting, we need it for human rights, environmental protection, and the rule of law. The blue one is the rule of law, the green one is environmental protection, and the red one are the human rights. So you need that for that. And then you have business associations, not all, but most business associations saying, no, we cannot afford that, and this will hamper our position on the global market. And then one main issue is, do we really have binding legal standards for that? And based on what we discussed previously, if we have binding legal standards, will they be implemented? And that can also be the tricky thing. If you look at the literature on mandatory human rights and environmental due diligence, that's the abbreviation MHREDD, mandatory human rights and environmental due diligence. So it's always combining environmental issues and human rights issues. Then there's a broad consensus also in the whole accountability literature that transparency is really crucial for everything. And if you look at, for public administration, this is, there's a broad literature on that for a long time, but also for corporations, there's a broad consensus that is not only about financial reporting, so the financial reporting you needed for investors, etc., but then when it comes to all these other issues, it's very much about other kinds of reporting that then will also have, this kind of transparency will also have a preventive effect. So if you know that at the end of the year you have to disclose this information, for example, on your impact on climate change or on other impact on the environment or on the way in which you're treating your workers, then you will already think at the beginning of the year, okay, I should perhaps also change my practices. Sometimes it's also, transparency is also seen as a less invasive tool. What may be indeed the case if transparency is already the game changer. Often it's only the starting point and you need then more somehow binding instruments. Yeah, and there are a lot of points, if you look at the literature, people arguing what are the advantages of reporting obligations for companies. So, for example, for governance, also in corporations, also to create enhanced risk awareness. So if you don't bother about your supply chains or about deforestation, then of course you don't know anything about the risk. If you have to look at that and if you have to make that transparent, then you will also see, okay, that's risky, we should probably look for another provider or discuss with our provider that the provider should perhaps somehow change the practices. And of course, transparency is extremely important for any kind of stakeholders, for civil society, because this is really what civil society work is based on. There are also studies showing that this can also be an incentive for corporations to apply human rights policies. So therefore, indeed, this is something that is becoming to be established. And what is also interesting in this debate is that even if the government does not implement it very strictly, there are also some businesses that say, okay, we are doing that anyway on a voluntary basis. And this is specifically the case for many trading companies that think that their customers want that. So if you have the big food providers, for example, the supermarket chains in Germany, they will probably all apply that more or less on a voluntary basis because they think, okay, if we get these scandals, then at the end our customers will not come anymore. And there have been these bad cases. Probably you have heard about all these bad cases everywhere in the world. But probably the biggest game changer was a Rana Plaza case in Bangladesh, where back in 2013, a textile or a building with even several textile factories collapsed and with more than 1,000 casualties. So that has been really a game changer, showing that it's nice that you can go to a shop in Brazil or in Germany and buy a T-shirt for very little money. But then, what's the responsibility behind that? If you know that the workers are living under dangerous conditions and that even the building is not safe and just collapse. So therefore, Of course, that was an extreme case, but these extreme cases always also have been some kind of game changer in these kinds of debates. Yeah, again, we also have limitations. So, and this can also be observed with the first attempts to make that binding. For example, with the German law, that many companies just have developed some kind of tick boxing strategy. So they employ someone and say, okay, we have this form, and then we have we have fulfilled our reporting obligation. That's of course not what we want. Sometimes there's also a debate on the cost. And then when it comes to make it binding, it's also a question of what's the consequence if they do not comply. And this is there would be instruments in the German law that have not yet been applied for people who do not deliver the reports. There could be sanctions. But yeah, there are also more technical issues that can probably be resolved over the time. That, for example, the performance measurement is an issue. In Germany, there is a public administration that has been, it's not a totally new one, but it's a new department inside the external trade administration that has been established for that in the eastern part of Germany. And we have been cooperating quite a lot with them because they really struggle to evaluate these reports. So when the reports coming in from the companies, how should they know, okay, is this really what they need to report on, and if they report on issues, is this really realistic? And that's a big task for the public administration, and this is completely new. So they are really puzzled, and we had several workshops with them where we discussed where we discussed with them how they can implement that in the future. Of course, if you want to use this data, you also need harmonization of the reporting. There's of course a problem in many issue areas, and specifically in accountability studies, also in our studies comparing police accountability, that's really a mess because all these institutions are publishing data, but it's not standardized, so comparison is really very difficult. So this is probably something where also we as academia also have some kind of responsibility to somehow trigger standardization for reporting. And then what is also important, also that reporting and transparency, this is just one step towards accountability, but it's not yet accountability. So therefore that's also important for that. Yeah, so to make it effective, it needs to be somehow linked to credible and effective oversight, clear reporting guidelines, a robust institutional framework, meaningful stakeholder participation, and then also grievance procedures. And yeah, in theory, this is there at least in some European countries, and it will also be there when the modified CSDD will have to be implemented in 2028, 2029. But yeah, then it still needs to be, of course, also made reality. Yeah, if we look at the CSDD, it's there. So you find that at several places. So companies falling under the CSDD, they will have to disclose this information once a year. And then it goes again to these administration who look at that. So in principle, it is there. It is still there even after the Omnibus, but the main issue is that the scope of application of the whole directive is much smaller than it used to be before the Omnibus. So this is what has been changed earlier this year with this Omnibus reform. This is also extremely unusual because usually, and I even think there's no other case where it worked like that. So usually you have a European Union directive, and then the directive says within 2 years, member states have to implement that in their laws. And then it will become binding directly upon companies, citizens, etc. Here, we were still in this transition period when it was amended, and everything was reported and also watered down. So this is quite unusual. And probably the most interesting thing is that the scope is much smaller now because it's now only for companies with more than 5,000 employees within the European Union, with 1.5 billion euro annual turnover, and that's limited even in Germany to only 200 or so, or 300. It's a very small number compared to the previous version where it was 5,000. So that's really a big change. So it's not only the SMEs that are out, and also the bad thing is that the SMEs are not completely out because they are often the supply chains of the big ones. So therefore also reducing the scope is not also in that respect, it's not really helping the SMEs, but it's only helping the big ones. Yeah, and there are also several other issues that have been watered down. And therefore, I think that indeed this will also reduce the Brussels effect because simply the number of companies concerned is much smaller, and that, of course, then also transfers throughout the supply chain. But because if the number of companies falling under that in Europe is smaller, then it will also be less suppliers in Brazil, for example, falling under in the scope of the directive. Yeah, similar in the German. I will not talk very much in detail about that. The funny thing is that the current government, in its the government, the biggest, the Conservative Party that is in government currently, they promised for the last election that they would abolish the supply chain law, knowing well that there is this European Union directive, and a member state is obliged formally to implement a European Union directive. So a member state that does not transpose a European Union directive will really get tough troubles with the European Union. So therefore, they of course knew that they cannot. And finally, what will happen is that they, when they transpose the directive into German law, they will rename it. So it will come back under a new name, but the content is quite similar, and the reporting issues they are, and also the sanctions, they are simply not applied for the moment. This is something that we are also discussing from a rule of law perspective, because that's somehow problematic. If you have a law and the government says, why applying this law? So usually in the rule of law system, also the government is bound to the law. It's clearer, of course, if it is about with laws impacting citizens' fundamental rights. So here it's not, it's somehow, so it's a facilitation for companies that do not have to submit reports, for example, but nevertheless, we think that in the rule of law system, it's not a good idea that, that the government says we somehow suspend the application of a law. Yeah, so there are also some amendments, but that will be then history, of course, when they implement the CCCCC. So therefore, I will not talk about that. But then, what is probably interesting, and I already briefly touched about that at the beginning, and that's one of our conclusions also. This could probably be very easily solved with what companies use already along supply chains. And we know from our people in our research center, for example, who are working on resilience of supply chains against crisis. Of course, everything is extremely digitalized. So now, and this is also a solution to become more resilient against crisis, that you have all the information. So, for example, the information on all your providers worldwide, and if you see, okay, now unfortunately there was also this case where a ship was blocked in the Suez Canal. So if a ship is blocking the Suez Channel, then unfortunately this will mean that many ships coming from Asia transporting goods to Europe, they will have to go across Africa, and that takes 1 or 2 weeks longer. And of course this is an issue with supply chains if it takes 1 or 2 weeks longer. So if you see, okay, there's a problem with the Suez Channel, then you have all the digitalized information and can see, okay, we still have a stock there, and then we can, and we argue that all these reporting issues, they could be easily integrated into that. And of course, it's not our original idea, because if you look at the CSDD, it's already in recital 68 of the CSDD, already in the original proposal of the European Commission. So they already see, of course, digitalization is the answer to all that. So you need to digitalize all these this information in tools that are easily accessible also for smaller and medium-sized enterprises. Probably this can also be the solution also for deforestation reporting and also for the farmers. And then they really cannot complain anymore that it is too complicated to use that if there are really easy tools where you have that all digitalized and also with the help of AI. So I'm not too pessimistic that this can be somehow solved in the near future, but of course this needs to be somehow triggered. So you need research on these kind of digital tools. You need probably also some financial help by governments in order to establish that. But this is probably one of the main answers to that. Yeah, and then probably finally for our debate on the Mercosur, so if we somehow summarize what we have discussed this afternoon so far, I would say, that for the Mercosur, that it's likely to happen that in some issue areas the Brussels effect will become more important, but then there will be probably big differences between industries, and that's then very much depending upon the markets. And that's basically what I wanted to discuss with you. So we have seen that the Brussels effect is not new, but already exists since the European Union started to do product regulation, and this was not only the European Union that in this form only exists since 1993, so it was already the early European economic communities back in the 1950s that were established in 1957, and then the European Community. The data protection was somehow the interesting forerunner example for the Brussels effect, but is not the only one, as we saw. And for supply chain due diligence instruments as deforestation regulation or CSDD and others, this is a new variation because this is what we call foreign corporate accountability.
Okay.
That's basically it.
Thank you. Thank you very much. Well, Hartmut, thank you very much, and welcome again to Campinas. Of course, it's not every week that Instituto de Economia here receives the Director of Research Center, whose agenda reads as if it had been written for this seminar room, right? I believe that GSVC Center questions how do global chains functions in times of crisis, and how can they be made more and more resilient is our question too. And the fact that Brazil is one of our case countries makes this visit the beginning of something, of course, not a courtesy call only, right? And I should disclose with pleasure that I'll make some comments also related to the paper that we are thinking about writing. And also I'm talking here because we meant to talk later about this paper, but maybe it's better to talk it with the public here, and also to maybe Petra can hear us later and send us comment later also. Okay. Well, I'd like to three things I would like to praise before I push some questions. First, I believe the legal precision is something that economists in this room need very much. We talk a lot about CSDD as a single object, and you show us that the object is moving, right? Article by article from the 2024 directive to the Omnibus first, and also the German amendment that would try to abolish the German reporting duty. And I think that granularity is rare and precious, and most of what circulates in our field is somehow outdated. Right? So you bring us to speed of what's going on right now. And second, I believe the conceptual bridge, grounding due diligence in accountability theory, like you mentioned, both Exacta and Forum, give us economists a vocabulary that we lack, right? we tend to jump from regulation to incentives, and the relation concepts of answerability is exactly what the debates need, I think, needs. And third, I would take it to be the sharpest in the deck. Reporting and transparency are not accountability, right? I agree completely, and my comments are, in a sense, three variations on why that line is even more consequential than the slide show, I believe, right? And I'll make three comments and make some questions also regarding the change point of view, one from the point of geopolitics, and one from the communities at the bottom, right? And close with 2 or 3 questions. It'll take more or less like 10 minutes, I hope, okay? My first comment is, where does the Brussels effect live, right? My first comment concerns the vantage point, because the Brussels effects literature, Bradford, as you mentioned, right, and market power Europe and geoeconomic power Europe, also debates, looks from Brussels outward. The EU has a large market, strict preferences, regulatory capability, and therefore its rules travel around the world, right? Your limitations side already plants the seed of doubt, right? Because of course companies can avoid the EU market. Third countries' law can of course also contradict EU law. Now, I want to radicalize this point a little bit, right? Maybe that's something that I don't know if it's my idea or Petra's idea, right? But it came up in some of the exchanges. The Brussels effect is not a propriety of the regulator. Maybe it's a propriety of the chain itself, and so it can be measured, right? So let me answer your discussion questions. You questioned, in which industry will the EU Mercosur agreement extend the effect, right? I believe there is a natural experiment that sits in my own state, the state I came from, Pará state. And I will consider 3 mineral chains that all live the same state, Pará state, under the same domestic legal order, the same licensing authority, and the same constitutional consultation right. First one, bauxite and alumina, right? They flow through, as you know, better than I do, a single Nordic lead firm, Norske Hydro, from Paragominas mine and Alunorte refinery, that's the largest in the world, to European smelting and EU market, right? Here, every instrument you showed us has a channel to travel down. The CSDDD is Corporate Sustainability Due Diligence Directive. Reaches the lead firm, certification schemes cover the sites, financing and reputation sit in Europe, right? So the lever bites. Whatever you think of what is, it delivers. With some precision that you lawyers will enjoy. Much of the alumina lands first in Norway, which is not in the EU, right? So, but of course the Brussels effects runs partly through onward processing into the single market and partly through Norway's own Transparency Act, which binds hydro directly. So, a Brussels effect by proxy through a non-member. So a nice complication for the theory, maybe. The second chain would be nickel. In case of nickel, Vale company in Brazil, and the Puma ferronickel leaves the same state for Asia, above all to China. So there is no European Union buyer, no European Union instrument, no channel, and the battery regulation, due diligence duties in EU, which would be the relevant hook, are postponed to 2027 anyway. So the lever does not run empty because the rules are weak, very weak. It runs empty because the chain never passes through the node where the rules live. So it's a property of the chain,
Yep.
right? Third, gold. Tapajós gold leaves the state largely through informality and origin laundering, right? And here's the uncomfortable effect. The EU has had a dedicated binding regime for gold since January 2021. That's the conflict minerals regulation. Yet, Instituto Escolhas study found that 94% of EU 2023 imports of Brazilian gold were at high risk of illegality. 93%, right? So verification presupposes a traceable chain of custody, yet laundry attacks the act of tracing itself. So no formality, no verification, no Brussels effect,
Yeah, indeed.
right? So the same origin, Pará state, my state, same institution, three
Yep.
geometries, three fates of same regulatory power. So my answer to your question is EU, Mercosur will stand the Brussels effect where chains are already Europe bound, when they are also formal and concentrated in reachable lead firms. Aluminum, yes. Beef and soy, only conditionally, as you mentioned already for some studies, because as Bastos and Lima and Vaca Flor showed, exporters can split their flows and send the compliant product to Europe and the rest elsewhere, China. Nickel, no, not at all. Gold, neither.
Yeah.
And since the agreement is mostly tariff geometry, it changes the attractiveness of EU market at the margin without changing the geometry of the chains, unless the sustainability chapter acquires teeth that currently it does not have, right? We can even measure the effects potential chain by chain. I mean, destination share plus concentration index, Hirschman stuff. Of course, that Hirschman himself built in the appendix of his 1945 book. The very book that gives us the idea of market power is a partner cost of exit, right? As in the case of soy, is quite clear. Before antitrust lawyers rename it in the Hiefendahl Hirschman index, right? That's my first point. My second comment's a little bit smaller. Regarded one of your slides about reducing scope, reducing the Brussels effect. Yes, the Omnibus reduces the effects scope, but I would push further. The 2025-26 sequence is not noise around the instrument. It's probably the evidence about the instrument's purpose itself. Because if you line up the timeline you gave us with the other half, on the sustainability side, the Omnibus cuts the CSDDD scope, deletes the harmonized civil liability, as I understood, softens the risk analysis to reasonably available information, perhaps most of the information not reasonably available, right? And the battery regulation due diligence is stopped by 2 years. The deforestation regulation is postponed again, and as you showed, the German legislator moves to abolish LKSG reporting duty and confine sanctions to severe, in a vague way, violations, right? So on the supply side, in the same 18 months, we had the critical, on the other hand, the supply side, critical raw minerals material acts strategic project list, including one project in Brazil, a nickel and cobalt refineries in São Paulo, the resourceful EU acceleration plan of December 2025 with its new European Critical Raw Materials Center, and the EU-US Critical Minerals Action Plan under Trump of April this year, right? So every conduct, instrument softened. Every supply, instrument accelerated under documented pressure from Chinese exports control also, and American tariff coercion, some of it aimed at this country, right? Both Brazil and of course, Germany also. So I believe that the pattern is consistent with a simple reading. Your slide says it. The EU is far from being a full state. Its hard power is very limited. Regulation is the power it has. So a standards-only power operating on a supply anxiety in a three-block global geoeconomic rivalry will demand of change the maximum that does not endanger its own supply, which is precisely the documentable minimum. And we will omit the one requirement that could interrupt supply, which is communities' right to say no, right? It's what Petra has been talking about, verifiable, and you, of course, also verifiable, but veto-less, right? And I do not think it's a drafting accident. It's an equilibrium, sort of. That's why I would answer your question, Mark, not with the Brussels effect is shrinking, but with something more pointed, maybe. That the Brussels effect is being spent deliberately to purchase supply security. Supply is much more strong than CSDDD, right? And one connection back to your accountability frame is your de facto slide lists civil society using EU standard for lobbying, the CAC and Seeking's boomerang in effect. Note that this is exactly the lever the Omnibus weakens. Less reporting, fewer artifacts in public, less for the forum to work with, right? So the retrenchment is not neutral across the actors involved in relations. It specifically disarms the forum and rearms the actor, right? My third comment, what checking cannot see, the view from the communities, what's more important here in Brazil, especially Pará state, right? Goes to the bottom of the chain of this comment and to the deepest layer of your line, reporting is not accountability. The question I want to put on the table is, what kind of rights can verification see at all, right? Some harms are event-like. For instance, a forest cleared after a cut-off date, and a satellite would settle this event is there, right? Your digitalization slide is right that the tools help here, right? But the right most at stake where mining meets indigenous and quilombola communities in the Amazon is not an event. Consulta prévia, we call here consulta prévia. It's a free, prior, and informal consultation on the ILO Convention 169, which in Brazil has supralegal rank, protects the quality of a process, where the people were genuinely informed if they could speak and could refuse also, right? And a hollow consultation process produces more and better documents than a genuine one interrupted by dissent. So the compliance artifact is endogenous to the violation. No? So for this class of rights, verification does not under-detect at the margin. It is systematically confounded. And the certificate then circulates as proof that the right was honored, right? And of course, I think you cited this, or Petra cited this, one of our dialogues. Sociologists of law have a name for this last step, Laura Idman's legal endogeneity, right? The law gradually accepts the paperwork itself as a reality, right? Your light say documentation rather than transformation. Elderman explains why documentation becomes the legally recognized transformation, right? Two illustrations for the public records of the very chain I described it, and then I will stop and make the questions. An industry audit report covering Pará aluminum operation describes consultation with the neighboring Quilombola community as being currently conducted. Currently being conducted. In the present sense, after certification had been granted already, right? So the prior of the consulta prévia, right? The prior is contradicted inside the audit document itself that's saying that the consultation is still going on, right? And in September last year, when Barcarena, Barcarena is very close to Belém, right? Barcarena residents' claims against the parent company were dismissed in Rotterdam. The defense rested, among other things, of being duly licensed and monitored and audited by the competent authorities and independent entities. So is that documented compliance functioning as a shield in court, right? So the accountability instrument was inverted into an answerability instrument for the company, right? To clean its hands, basically. And here's a twist that makes Brazil the hard case for the whole field, in which I offered to the center as a research provocation. The due diligence literature assumes a governance gap. I mean, a weak host state that European law fills and pushes it to fill through supply chain pressure, supply chain regulation pressure. In this case, the premise is inverted because the Brazilian consultation right is stronger than anything in the EU instrument. The LLKSG Annex, as you know better than I, does not even include ILO 169. So the deaths in Pará is not norms, it's enforcement. So a European channel that accepts the weak version, a hearing, a certificate, right, does not fill this gap at all. It risks undercutting a stronger national right, right? And your and your condition for effectiveness slide, as you mentioned there, contains the remedy. I believe, if you read it very strongly, that's meaningful stakeholder participation. That must means that right holders participate in the verification itself. If it's not in European law, a European company would not open space for the communities to participate in the verification itself, I believe. And the 4 Barcarena communities that launched their consultation protocols at the State Assembly in November 2024 have, in fact, already drafted the evidentiary standard the directive lacks, I think, right? So 2 minutes for the concluding questions. One, EU Mercosur, that's something that we have to develop more, of course. But beyond tariff geometry, does the agreement contain any de jure hook in the trade and sustainability chapter or elsewhere on which due diligence obligation could ride? Or is it likeless effect on our subject indirect, I mean, through the ratification politics in Europe, hardening instruments like the EU DR? Right? 2, on accountability theory, can a private certification scheme ever constitute a genuine Bovens forum, given that the actor selects and pay the auditor that's going to supervise them? What institutional design, I mean, supervisory rules on how much authorities may rely on industry schemes, for instance, would make the forum independent enough to reserve the name, right? What can we design? And 3, on digitalization. I mean, it's the most unfair question, I must say beforehand. Satellites can verify deforestation. But what's the digital analog for the quality of a consultation? If there is none, and I suspect there is none, then doesn't digitalization also systematically deepen the asymmetry between event-like harms, which get ever cheaper to verify it, and actual deliberative rights, which remain invisible to digital tools? I mean, in other words, might the technological fix make the structural problem worse precisely by making everything else better and easier and cheaper, right? So Hartmut, thank you very much for your genuinely stimulating talk, for choosing Campinas as I stop here in your journey to Brazil, on the evidence of this afternoon, the partnership between Bruno, myself, you, Petra, between our centers begins, I think, very well. Obrigado.
Obrigado.
Yes.
Okay, all very interesting issues. So probably the answer is that there is no fit-for-all answers because it's really very much varying from sector to sector. Also, answering to your comments, indeed, it makes a difference how much and how tough rules the country at the other side of the supply chain has. That's one issue. And then, so for this interesting case study on the participation of the indigenous communities, that's of course extremely interesting. I'm not sure if this would really work if the European Union would say, okay, this needs to be everywhere. But then the interesting question is, how does this work together when Brazil already has these rules and there's a gap on that in the CSDDD? Where I would argue, okay, then, of course, this has to be merged in the concrete case, even if this would then not be applicable for a supply chain to Africa, for example, if they don't have such rules. So that would be potentially my answer to that. Of course, the CBAM issue, that's probably the most tricky one. Potentially also referring to your point, that at the end, it's also very much about the European Union trying to develop instruments that are in a way suitable and acceptable. So as the European Union has this structure, not as a full state, and very much relying upon regulation, but lawmaking is also a compromise making. So the European Union is in a way a compromise making machines between these 27 different actors with very different political majorities, with different groups in the parliament. So very strong Brussels lobby groups. So probably if you go to Brussels, you don't have many cities in the world with so many lobbyists. So that everything is very much under pressure there, and therefore much of the result is indeed what has been called the additive logic of decision making. So a compromise. There are different compromise mechanisms. One that is quite interesting that they often use is leaving the rules a bit fuzzy, and that is de facto a shift towards the Court of Justice. Because if the rules are fuzzy, of course, sooner or later there will be a case going to the Court of Justice, and then the Court of Justice will say, it's this way. That's often not so bad, because the Court of Justice is quite good in somehow, they have a good vision on how to streamline things. But it can also be what we call this additive decision logic, what means, and this has been nicely shown also in several studies, the compromise is there's a bit of the French position, there's a bit of the German position, a bit of the Spanish position, and you put everything in it, even if it is contradictory. And probably European rules are often internally very contradictory, what also means that at the end it will be the Court of Justice that has to clarify things when cases pop up. But then the compromise can also be, if European companies find that climate change measures are somehow endangering their position on the market, then you establish such an instrument as CBAM. That's probably There's probably no other country in the world that really likes it. So yeah, that's I would also argue that probably CBAM is also a specific case because all the other instruments that we have discussing, they are not. There's often a real purpose behind. What we did not yet discuss, but what is probably also an interesting aspect, is that all these omnibus issues that we discussed became possible because there was a shift in majority in the European Parliament since the 2024 elections. So before the election for many, many years, there was a stable majority of Social Democrats, Liberals and Green Party in several constellations. So, but they for a long time they had a very stable majority. Now this majority is gone due to this trend to populism in several of the member states. And now there are 3 or 4 groups of parliament that are relatively strong that are against the European Union. So they are in the parliament, but they say, oh no, we should. Some of them even say we should leave the European Union. Others say the European Union should be reduced to a minimum. And so this, for example, this CSDDD Omnibus only became possible with a majority of the conservative group in the European Parliament and some of these anti-European groups. So that's really quite crazy. But this is how things work, and this would not be possible in the German political system because, at least for now, it may change in the upcoming months. But until now, the Conservative Party says there's a firewall, so we will not. There's a firewall between us and the extreme right populists. We will not cooperate with them anyhow. The firewall does not exist in the European Parliament, so they work together for this instrument, unfortunately. Yeah, so this is part of that. But then the interesting thing, issues also for research occur where you have European Union rules that somehow work with this Brussels effect for very different purposes. And of course, some of them can be, I totally agree that some of them also create new dependencies, can also be seen in a very critical ways. While others probably have quite good reasons. So, for example, to protect consumers against dangerous chemicals, or to products that do not work or that endanger human health and things like that. So there's probably also a lot of potential in the Brussels effect that could be then at the end also beneficial for consumers in other parts of the world. So therefore, I clearly see, and probably most studies looking at that come to the result that we have to look at this in a case-to-case basis. Otherwise, it's not really possible to say we need more Brussels effect, or but it's really very important. And I also liked your examples with the minerals, because that's really what we need to look into specific issue areas. And yeah, indeed. Things are easier if there is a synergy with the interest, for example, of European companies that need raw materials. Then they will probably be much more open to comply with rules compared to other issue areas. And yeah, then also your gold example just very nicely fits to also our studies on illegal supply chains. All these instruments, all the Brussels effect, everything, all the international legal order, everything what is escaping from the system, of course, will not be covered at all by this. And I agree, and I know also from, we had an interesting conference with Böll Foundation in Berlin recently, where they looked at that, and I agree with them that this is something that should not be ignored. So politics somehow seem to ignore these illicit and illegal supply chains. But if we look at that, okay, there's really a lot of organized crime behind that, and organized crime also means that there will be victims, people who are exploited, people who are potentially even killed if they do not agree to things. So these are really structures that, of course, probably it does not make sense to say everything needs to be officialized, and informal economy probably in some countries work quite well. But then when it comes to organized crime and to a few very rich people making a lot of profit by exploiting this, and at the end it's also, of course, we are in a public university. I also work for a public university. I would also argue these people who make a lot of money with illegal activities, they also do not contribute to the common interest. They do not pay taxes, and they do not contribute to public education. So therefore, this is of course something that needs to be tackled. And then the interesting question is, for example, for the gold supply chain, why is this possible? That this escapes from. So why do, for example, in Brazil, why do public administrations somehow tolerate that? And even in Europe, why? Because it's also a question of how intensively do you go against that. Mm-hmm. So things can be illegal, but if there is nobody really investigating, for example, then people can just do it.
Yeah.
Mm. And yeah, of course, the problem is that with that is if there are opportunities to make a lot of money with illegal activities, somehow states are also often quite powerless, because even if, and we have had these cases, and now Trump has all these people with drug people in Colombia, etc. So even if they arrest some of these people, or they even kidnap one and brought him to New York, even if they arrest some people, there will be probably others.
The network will keep on going.
That will keep on going, and you probably also have this problem in some of the bigger cities in Brazil. So that, but then it would be indeed. And therefore I think indeed it's worth doing more research on this illicit and illegal supply chains, because we do not know much about why it is possible that in a system such as Brazil, for example, where I would say it's probably very much related to corruption, where I would say, okay, but there's a well-established legal system, so the instruments are all there, but at the end, it does not work.
On the ground. People that are on the ground trying to repress criminality are corrupt. And of course, some politicians in the local level.
And then I also agree to what you say, that these Brussels effect, they will only work if there is a supply chain going through Europe. And the Norwegian case is also very interesting in this, because they are not officially a member of the European Union, but it depends
on the market.
It's so you have a periphery in Europe of countries around the European Union, and Norway is probably the one that is more or less de facto a member of the European Union.
Yes.
And there are also many people in Norway who would like to accede to the European Union, but then they had several referendums on that. And of course, it's also a very rich country, because they have all this oil that is sold everywhere. So it's probably now the richest country in Europe. And therefore, there are probably also many Norwegian people who say, okay, we do not want to share that with the poorer ones, because they're even also inside the European Union, even if the level has increased everywhere. So if you look at Portugal now compared to back in the 1970s, of course, it's a huge difference. But nevertheless, there are still differences inside. So if you look at the wage levels, I always have these problems when we apply for European research funding, that my staff is so expensive because we have so high wages in Germany.
Yes. Okay, I think it was great. Thank you very much, Hartmut, and I'm looking forward for us to keep on cooperating.
Yeah, me too.